Hello, everyone out in webinar land. Welcome to our webinar on AB 130. Today, we're going to have Jasmine Hale, who runs our corporate counsel practice. We're joined by Paul Windust, who runs our enforcement practice. And we've got a rare appearance by Steve Weil himself, who is mostly retired at this point, but he was willing to come and conduct this conversational webinar today for you guys. A couple quick announcements. This is being recorded in case you didn't catch it at the onset. We will post the video on our homepage of our website as well as all our social media. So if you have colleagues or board members who want to watch it, you can find it later. Try to hold your questions till the end if you can in the comment section. And we'll see how many questions we can cover. If we don't get to your question or you walk away with more questions, feel free to email me. Again, my name is Jill Jackson. I'm the Director of Client Relations for Birding and Weil, and I will put my email in the chat section and you can find it there. So take it away, guys.
Welcome, everybody. Jasmine, I think you were going to lead off with a summary of AB 130 as it relates to homeowner associations under the Davis-Sterling Act.
That is correct. So, hi everyone. AB 130 kind of caught everybody flat-footed. It was part of a budget reconciliation bill. It's pretty much like we're going to allocate this much money of the California budget to X and Y and Z. Of course, there's always little amendments that get put into the statute. Legislators, whether they're state or federal, they can't help themselves from doing those kinds of things. The unusual thing is that this particular wording was stuffed into the bill literally at the 11th hour, the night before it was adopted. Normally for budget bills like AB 130, it's supposed to be non-controversial, pretty just benign stuff. And CAI and I think CACM, those are organizations that support housing community associations and managers in California. They, adamantly opposed the underlying legislation that that this part of AB 130 was a part of. It was actually a part of Senate Bill 681 by Senator Wahab, and it was to impose this $100 cap. I'll explain that in just a second. And so I think it's helpful to kind of understand how the hell could this have happened in the middle of the year? For most people who sort of even tangentially follow legislation, you're like, hey, doesn't this stuff normally kick in at the beginning of the year in January? Like, it's unusual that something takes immediate effect. And because it was in this reconciliation bill that just basically authorizes the budget for California, that's why it did take immediate effect. But it should, this particular change and amendment should not have been in the bill. You're not supposed to have things that are opposed by groups that have lodged positions of opposition. So that's, something that the industry is going to have to grapple with. But I did want to at least give context for where this came from and how and why, because I definitely have had a lot of freaked out boards, a lot of freaked out managers that are like, well, what? Like, I have a disciplinary hearing tonight. What am I supposed to do? So a couple things. First, the bill took effect on July 1st. That means it is operative. You don't wait until January to start following what it requires. Next, it amended two parts of the Davis-Sterling Act, Civil Code 5850 and Civil Code 5855. And we're going to go kind of over conversationally all these different changes and sort of questions and scenarios. But the big picture of what the bill did was, it imposes a $100 monetary cap for violations. There is a carve out for health and safety violations that have to go through an open meeting written finding process beforehand. It imposes a, obligation on associations to allow a homeowner to cure the violation. And if they do, then you don't get to do disciplinary action and hold a hearing. If homeowners don't like the outcome of a disciplinary hearing, then they can they can ask for an IDR, internal dispute resolution process. So those are the big structural changes to AB 130 and to the Davis-Sterling Act for enforcement. So now let's get into the nuts and bolts. Take it away.
Thanks. This AB 130, as Jasmine said, it was enacted just right at the last part of the legislative session, it amended more than 50 laws. Of those, we just have 2 that we are concerned about today and that you all are concerned about as you're guiding your boards or for directors as well. And the changes are not very extensive. I mean, the wording wise, just a couple of sentences here and there. But with brevity comes an awful lot of uncertainty. And we're going to talk about those areas of uncertainty, like somebody just wrote us right out of the gate, hey, what's a continuing violation? And of course, the statute doesn't talk about that. The other unfortunate piece of, we all like when legal mumbo jumbo is short, but then that raises a lot of questions, and we're going to try to answer those today. Unfortunately, a lot of those questions are going to be ended up being resolved in small claims court, which is kind of like the Wild West of, courtrooms, or maybe even in Superior Court. And so as people start enforcing their documents under this new regimen, we're going to find out, what some of these concepts mean. And maybe if Jasmine and her fellow colleagues on the California Legislative Action Committee, if CAI have their way, maybe this thing will be repealed. More likely, maybe it will be amended so that it makes more sense for those of you who are in the trenches actually having to implement that. Okay, so we've identified a number of issues which are baked into some questions that we're going to kick around today. The first one, what are the new procedures that are required by this law that's already gone into effect July 1?
Okay, well, it's kind of like the hokey pokey, you got to put your left foot in, you put your right foot in. I'm totally kidding. You have to have like a little bit of humor about this, everyone, because, so the procedure is the same as it always was. If it's any violation that does not involve what the board considers to be a threat to health or safety. So we're just going to say regular violations. I didn't put my trash can in on time. I've even got a notice from my own HOA for that every once in a while. I'm like, David, come on now, drag it back in. So those types of benign ones that don't involve safety threats, it's the same process. It's, send them the hearing notice, have the hearing. The small tweak and change to the process is that it used to be up to 15 days after the hearing, the board had to provide notice of the results, and now it's within 14 days, so they shaved a day off. So that's the structural process. Again, this right to cure that is now present in the statute, and we'll definitely dig into that more with continuing violations and all of that. But basically, the statute says if the homeowner cures the violation before the deadline, before the hearing, then the association cannot hold the hearing or impose disciplinary action. So let's say it's the trash can thing. And this, HOA is like, hey, you've done this 6 times, we're having the hearing. If I bring my trash can in before the hearing, then they can't hold the hearing. So they would have to cancel the actual hearing. So that's the process for all of the non-safety health types of violations, or health and safety types of violations that can have higher cap, can have higher disciplinary fees than just the $100 cap. The board has to, before imposing the violation, make a written finding at an open board meeting that the violation is a threat to the health or safety of the association's common area or another member's property. And that's precisely what the statute says. There's definitely a lot of room for how one's going to interpret that. You mean like, okay, so I can have a, no grading, no unauthorized grading, or no, fires in the common area, but I can't go and stalk a member? That would seem a little crazy. I think most of us would be like, shouldn't be able to do that. Physical kind of conduct that doesn't affect property, but it affects people's quiet enjoyment and ability to live in their properties. So there's definitely a lot of uncertainty in terms of that. But again, the process, because that's the question, is the process for the health and safety violations is have this open meeting, the board makes this written finding at the open meeting. Grading of, unauthorized grading to slopes is a threat to common area, can affect slope stability, whatever the finding is on why the board considers it a threat. Then the board can have the hearing and proceed with the disciplinary action. Paul, do you read anything else into it?
No, that's about right. I think you covered most of the things that I saw in the bill.
Well, the thing that's absolutely screwy is, okay, so you're a manager, you're at a board meeting, and the open meeting starts at 6:30. And an item on the agenda is health and safety violation. And you're not saying violation concerning unit 12, right? You're just saying health and safety violation, and maybe it'll be something like barbecuing, in the common area where there's a lot of dead grass. So then the board has this discussion, somebody makes a motion, yes, let's vote on, would that be a health and safety issue? Answer yes. Then they finish their meeting. Now they have executive session. It's now like 9:30, right? Executive session. And now they're going to call in Fred for the purpose of determining whether, his barbecuing is a health and safety violation. And the reason that we're separating that is because, in theory at least, Fred's entitled to a private, personal meeting, a disciplinary meeting, not one that's in public. So there's going to be it's a little screwy about that. But anyway, that's the way it looks like to us. So one of the things that there's an awful lot of talk on social media, the internet, and even it was our very first question having to do with continuing violation. So the statute says that the board has the power to impose a fine of $100 per violation, or if it's less than in the statute, whatever's in the governing documents. So what is, quote, a violation, which has to do with this question, what is a continuing violation? And what are some examples? So would you guys just sort of nail the landing here? What is a continuing violation to the extent we can say what it is? And then how does that impact things like the amount of the fine, how many times we can fine, and how many times we have to have a hearing before we can fine?
Well, I think part of it is going to depend on how the association has defined violation. There's definitely case authority that associations and boards are entitled to sort of adopt rules that identify and telecast how they define things. And so if you defined violation to be, the ongoing ongoing uncured conduct on whatever sort of periodic measuring basis you're talking about, whether it's daily or weekly or monthly, that the start of that new period creates a new violation. That's kind of taken from the public-private nuisance statutes, where there's a statutory paradigm that we're not just sort of like plunking this from midair. That's where it comes from. I think that there might be authority for the board to take that type of approach. I wouldn't recommend they take it without having some sort of definition in their rules or their CC&Rs that identifies this is how we define violations to be. But Paul, what's your thoughts on that? Because you've got litigator hat on.
Right, yeah, I was going to say the definition of the continuing violation in the, I guess, fine policy is really important. It also needs to be a reasonable definition, because if we have to go into court and enforce these rules, we don't get the normal presumption of reasonableness that you get in the declaration or the CC&Rs. So if we're going into court to enforce the, continuing violation and try and collect whatever fines have racked up because of this continuing violation, the burden of proof is on the association to define its continuing violation in a reasonable way. So for example, if the violation exists in a certain time frame, if it's still there, for example, is the car parked in the guest spot for 72 hours, that's a continuing violation, or every day. It just depends on I think the type of project that's at issue, and the importance of the rule that you're trying to enforce. But I think the definition is really important. The code has left it up to the association to say what a continuing violation is. And as long as it's all in the rule adoption, everyone gets to comment like, oh, I think this continuing violation rule is reasonable or unreasonable. And if you have that dialogue, then I think it becomes more of a enforceable type of definition.
Well, and to that point, because I've already had clients reach out and say, we want to restate our enforcement policies and update our fine schedule, because violations can be so specific, and there may be a real difference between the car that's parked in the guest parking. If you're a project in the city and you have 200 homeowners and 78 parking spaces, that might be really serious, like big issue. And in a different location, but not a threat to safety, and in a different place, it's like, hey, I didn't turn in my architectural application. I mean, serious, no doubt about it, but maybe it's not the same level of like community ire. And so when I've been drafting policies, I've sort of provided the board to have the ability to set the periodic measuring, so that a car parked in the guest parking more than 24 hours, the next 24 hours starts a new violation, but you have to put the designated period of measurement in the hearing notice itself, so that you're giving due process, but there's also flexibility. So I've kind of tried to build in a bit of flexibility into the definition for that purpose.
Right.
It strikes me that both as to what is a continuing violation and what is a health and safety violation, that drafting these things in rules or amended CC&Rs will be very helpful for people like Paul, who are actually going into a judge who doesn't have a lot of HOA experience. And what we want to do is to say this is a community standard. And also, I think it will be very helpful to adopt that standard after we've had a community discussion about it. So if we step back a minute, this law, which limits fines to $100 a violation, invites a discussion with the board and management and the members as to what kind of association do we want? Because now, if we're going to be fighting for these violations, fining is probably not going to be very effective in most cases. I question how effective fining is generally, but especially now. And so I think boards are going to have to face the question, do they really want to amp up quickly IDR, ADR, maybe going to court arbitration? And that's a different dialogue than we've had before. And I think that does result in drafting rules defining what a health and safety violation is. Now, in this regard, the statute is absolutely no help. Here's what it says. A basic safety violation is an adverse health or safety impact on the common area or another association member's property. What does that have to do with a guy walking around with a knife? Drunk. Yeah, I mean, we really don't know. So I think we're going to have to make reasonable judgments, again, in part based on input from clients. Now, obviously, there's just no way around the fact this is going to involve a community dialogue or a board dialogue about legal fees. Paul, every time there's a bad law, we say it's great for lawyers, bad for everybody else. This is definitely one of those. How is this going to impact legal fees?
Well, I think what's going to happen is if the fine policy or the fine mechanism that we're now under isn't getting the cure, isn't getting the violation cured, what's going to happen is there's going to be the more formal enforcement process that I'm involved in, which is pre-litigation ADR, which usually takes the form of mediation, You can offer arbitration, but the other party rarely agrees to that. It's, you know, as you probably all know, it's an offer of mediation. They have 30 days to respond, but that mediation is expensive. You have to pay for a lawyer's time to attend. You have to pay for the mediator to attend. Now the mediator's cost is shared with the offending party, but my costs aren't. And you go through the mediation, and if you succeed in resolving the violation, great. If you don't, then it switches back to the board to determine, is this an issue that's important enough to the community to use association dollars on filing a lawsuit and taking it all the way potentially through a trial to get an order of compliance from a judge? That's a significant cost. It can, you know, it ranges from, you know, $10,000, where if you go to a trial, it doesn't happen often, but I've tried a couple enforcement cases and the legal fees can reach $100,000 just for that case. Now, if the association prevails in the case, we get to make a motion in the court to have the court award us the attorney's fees that we've incurred. But you still have to pay the $100,000 just to get to that point of prevailing.
Listen, we don't want everybody to hang up. So 30 years
The attendees just dropped by 10%.
times did you litigate through trial, arbitration, mediation, appeal, Supreme Court, whatever, where it was $100,000? Come on.
How many cases?
Yeah.
Two.
Okay.
Two in the last 20 years.
Okay, so really, we don't really know the cost until we get into it, because we don't know what the owner's defense is going to be. How many
Right.
depositions they
Or
want.
the owner might not even defend it. There's plenty of cases where the owner doesn't defend at all, and we end up with a default judgment.
All right, good. You freaked me out there a little bit. I want to just quickly tick off a couple of questions here. Mark Jones, how does it affect legally mandated actions? This law doesn't, except if there's somebody's not doing something legal, you can only illegal, you can only fine them $100, like we said. Jeff, what are the chances this will go away in January 2026? It's not going to go away, but it probably will get better. That's my guess. And then Raylene, let's see. Somebody asked, can we do the hearing before the finding of health and safety? And the answer is yes, you can. So one of the quirky things in this statute is that owners get to, this is like the fifth thing on my topic list. The law permits owners to cure their violations, in which case fines are not permitted. So can one of you talk to us, number one, about what this curing business is about? Like, when would it have to happen? And like before the hearing or after the hearing or before the 14-day notice goes out, whatever. And then also, what about, you know, non-monetary discipline? I know we're going to talk later about suspending privileges and that. And how does that impact by the curing as well?
Sure, I'll jump in on that. So on the non-monetary violations under Civil Code 5855, they're treated the same as the monetary penalties. So if the conduct or the issue is cured, I'll get into that, then you can't. So whether it's monetary fine or we're turning off your gate access privileges or whatever the HOA's levers are, those levers don't get to be pulled, full stop. In terms of like, when does the cure happen? That one's a little complicated for some reasons in the statute. So the code literally just says the member cures the violation prior to the meeting. So, you know, if you send a hearing notice and are like, August 1st is the hearing date, they would have until August 1st to cure, and they would, be able to avoid the disciplinary hearing. I mean, all of us on this, webinar can kind of wring our hands and lament that that's, absurd. What if there was, a special meeting that was called just for this purpose? Or does the association get a charge from management because they were supposed to have hearings and people cured and now there's no hearing, but management still had to reserve their time? maybe legal fees, so. But the code says what it says. So, I mean, that one I'm pretty comfortable saying if the member cures right up to the point of the hearing, then, you cannot impose the disciplinary action, whether that's fines or privilege suspensions. I do think reimbursement charges are separate and apart. There's nothing in the statute that says if a homeowner, crashes through a wall or runs their car into the gate and it requires $4,000 in repair, that the HOA is now out of pocket that money. If someone were to interpret the statute that way, I'd rather be on the side defending the HOA's right to recover hard costs. But what do you think, Paul?
Yeah, I think that's right. The thing I'm thinking more about is, I mean, it seems like a lot of red tape to gather everyone to a hearing, have management show up just to have the person cure the violation at the very end. It seems, wasteful and but I think we have to balance, due process with practicality at times. If obviously, if it's a violation that does cause health and safety and you don't have time to notice a hearing, I would say, time to call the police, right? In certain circumstances, if there's, drug use going on or some, dangerous behavior going on or something like that. I mean, I have a case right now where someone has a fob who doesn't live in a project in a very kind of like rough area of San Francisco. And with this new law, they're saying, well, do we have to hold a hearing? We know this person has a fob. We know he doesn't live here, but he can get into our building. Do we have to have a hearing? Or can we just turn the fob off? So these are the kinds of questions that, I think that now boards have to deal with because
Wait, what's the answer, Paul?
Say again?
You get the answer?
I told him to turn it off.
Okay.
I mean, I said, well, the guy's not a member of the association. He has no rights to a hearing and stuff like this.
Doesn't have anything.
Yeah. So I used that, yeah. But they're like, well, the fob is it's a little bit more nuanced. But basically, I just told them to turn it off because at some point, common sense has to prevail.
So somebody asked a really good hypothetical. Using the trash can example, the homeowner fails to bring in the trash can within the required 24 hours, but always brings the trash can in before the hearing or within 72 hours. And I read the statute to say we can't fine them for that.
Mm-hmm.
I agree. And I mean, I can appreciate that, homeowners who live in HOAs and they get the benefit of conformity of conduct. And, this law basically sort of encourages, we do what we want. But as long as I've, cured at some point before the hearing, like you can't really do anything to me. And I think that's pretty regrettable, but hopefully we can go on a common sense path like Paul's suggesting.
This is another one of those laws that either reflect a great hostility towards associations, directors, and managers, or just a gross level of misunderstanding as to really what it takes to give meaning to the community's desire for a standardized, harmonious community. This is just another example. So, and this is what it is. So this is our new reality. $100 fine either is probably not going to motivate most people, and especially if we have to retract it, before the hearing. So, okay, so what is our number 7 for you guys? What is the new enforcement landscape? Maybe you can tick those things off. They'll be familiar to everybody. I would just add, I think boards need to be a lot more aggressive and a lot sooner. So.
Agreed. So, I mean, the enforcement landscape, it always was and still includes, your disciplinary hearing to impose monetary penalties or non-monetary penalties like privilege suspensions. I've definitely talked with several boards already and said, hey, think about interactions with homeowner or resident and the association, and whether the association's, temporary cessation of that interaction, whether it's gate entry for people who go through a gate, and like now I'd have to get out and like type in my code instead of using a transponder or key fob. If I live in the city and Amazon delivers all my packages and the, HOA, delivers them to my house or puts them, behind the desk and cares for them. And, they no longer do that and the box just sits there. Like, are all of those little tiny interactions, you could consider them to be like privileges that are suspendable. Maybe it's, we're not going to consider your architectural application. So I've definitely encouraged boards to really reflect on their intersections with their homeowners through conduct and whether the association will be able to motivate behavior and compliance through those things. We've got internal dispute resolution meetings. Those are now baked into the process. If a homeowner doesn't like the outcome of a hearing, they can ask for IDR. I mean, they've always been able to ask for IDR, but now it's part of the process. There's alternative dispute resolution. Typically that's a mediation, like Paul discussed earlier. We've got lawsuits, small claims court, superior court. So, I mean, those are still your enforcement levers. You just may pull them faster or slower than you used to.
Wait a minute, I got a little dizzy there. Are you saying that a board can adopt a rule that says if you have been found to have violated the governing documents after a duly noticed hearing, we don't have to consider your architectural application?
I think depending on the wording in a set of CC&Rs, the board could certainly press the issue.
You're living large there. That will require amendment probably to the CC&Rs.
Sure. But other things where it's not as direct, and again, like some CC&Rs allow for the board to enact policies, and so I'm suggesting, like, this shouldn't be taken as like the word gospel for every HOA, but I'm suggesting that boards would be well served sitting down and going through their documents and finding out, are there little points that might motivate behavior?
Yeah. I want to come back to something, this curing business, curing the violation. The statute says this: if curing the violation would take longer than the time between the notice and the meeting, so longer than what, 15 days, let's say, then the board, as I read this, the board cannot impose a fine if the member provides a financial commitment to cure the violation. Okay, I'm sure there are stupider laws, but possibly not. What does that mean? Do you guys, or what, put it a different way, what do we advise our clients on how to deal with that?
Well, my view is I think that the financial commitment, again, could be defined in the policy. This as the law says, or the statute says, financial commitment, just like continuing violation. We're going to define the financial commitment. You pay the fine, and then when it's cured, you get your money back.
Okay, the hypothetical is somebody paves a new walkway on their front yard, and as part of their home improvement project, they put in all new windows, all of which required prior approval, none of which obtained the approval, all of which was super expensive. Probably can't be fixed in 15 days.
Right.
What is the financial commitment a board can extract from them to motivate them to do it, bearing in mind it's got to be, quote, reasonable?
Well, I mean, that is a very good question, Stephen. There's no guidance for us in the statute. I mean, for some communities, maybe they actually ask the association member to like obtain a bond. In the expensive windows case where someone's just shelled out, 6 figures to put in all new windows, you could definitely, I think it might be more reasonable to say, oh, well, we're going to ask you for a $100 because that's you know, how much we get to, you know, charge you for this violation. You know, that might just be the easy cost of doing business. You know, I think the board may have the ability, whether it's in the rule or, you know, in the hearing notice, to say this is the type of violation that we're gonna, you know, define financial commitment to cure the violation to mean X. And
Well, are we going to require, as an example, can the rules say that the owner has to deposit with the association an amount equal to X, the cost to restore the property?
You can, that'll never happen in practice, because
Right.
the person, if they're intelligent, will say, I'd rather have a judge make me do that rather than just do it. So, but, you know, and again, I think it depends on the violation. The violation you're talking about, Steve, that's one that's going to have to be litigated in my mind, because if the board of directors is adamant that these windows will not at all satisfy anyone in this project, and it's going to cause, you know, a lot of heartburn, and because they're just, and I don't care how pretty they are. The Dolan King case is the prime example, where this woman put in the most expensive windows I've ever seen in my life. The court said, sorry, you got to take them out. And
Because they don't fit with our architectural scheme here.
that's right, they did not fit.
Yeah.
And you know, so I mean, I guess when you get to my department, the law is good for us over here. Okay. In Jasmine's department, we're trying to figure out what the law means. But in a lot of the cases that we do, the courts respect architectural committees, they respect architectural decisions. The most important part when I'm going to court to enforce any of the governing documents is that I have a lot of evidence of communication from the association to the offending owner, asking, please, you know, you please submit your architectural application, you know, please comply with the parking rules, please keep your, you know, noise level down after 10 p.m. I have tons of documentation like that. And the association has followed their own rules in enforcement, the internal rules with like fines and things like that. I'm good. I'm solid. Even before a jury. I mean, I've picked juries in these cases, and I haven't found a single juror who says, I love my association. Not a single one. The best I get is indifference. But that being said, jurors understand the rules, and they apply the law to the rules. So,
All right. There's a lot of legal double talk. So try this on. So several of the managers are sending us questions, a few, which says, instead of waiting around and trying to beat the owner up to force them to cure the violation, assuming the governing documents permit it, would it be a more effective strategy for the board to use, quote, self-help, cure the violation, and then, assuming the documents were broad enough, levy a reimbursement assessment and maybe even lien it after that? Is that something that more and more boards are going to be thinking about, as opposed to these $100 periodic fines?
my concern about that is most CC&Rs have a notice protocol built in for use of the self-help, right of entry, you know, HOAs doing the repair. I mean, typically the HOA has the responsibility to give notice and the opportunity to cure the violation, even if the civil code didn't say so. A lot of CC&Rs have that baked into the cake. And even if they didn't, you know, someone like me, before it ever gets to Paul, is like, hey, it's reasonable to give an owner the opportunity to do the thing themselves before you just go in and do it. So I think that it's a possibility, but I would really hesitate the board just saying, hey, we're coming on Friday, we're gonna, you know, repaint your house because it hasn't been painted in 2 years and we've asked you a lot of times, so go team. I mean, I think that there's still got to be all those notices and cure opportunities, and after they've blown past those exits multiple times, then the HOA could more confidently use their self-help rights.
Self-help is scary, right, Paul? First of all, you've got to get a contractor. You've got to tell them they're going to go on private property. They're going to want an indemnity the size of Texas. If at all, you may want security or a sheriff there. I mean, there's a lot. a lot.
Right, well, I mean, that's interesting. I mean, yeah, the self, Jasmine's right. If you're gonna go with self-help, you gotta give a notice. You have to follow your procedures that are outlined in your CCRs. But even doing that, you're telling the owner in a hearing, we're coming on Friday at 12 o'clock to, repaint your house. That owner is going to call the police and say, these people are trespassing on my property. Whenever we've done self-help, we usually have a court order that says we can actually do the work. And even those court orders allow the owner to do the work in compliance with the court order before we do it. So it's nebulous and kind of like,
Unsatisfying.
yeah.
So the self-help language is really a threat, right? It's really a threat. And you'd rather, even though it's kind of a pain, go to court, get a court order, which will say, owner, you've done a violation. You have the right to cure it within 30 days. If you don't, then the HOA can't, and then they'll pay you back like that. That would be a better way to do it. Yeah.
Yes.
This is boards off. I mean, I know all of us have had frustrated boards. Like, why does the CC&R say we can enter and do the thing we need to do? And we have to go through all of this. They kind of look at hullabaloo. And you're like, I promise you, like, I am not just making this stuff up for permanent employment. Like, I would much rather you just do the thing. And it's frustrating for boards because, they say we've got the document and it says we can do the X. So I know that Paul and I have been on the, receiving end of a lot of frustrated boards where we've had to walk them through like why we're doing this painstaking process.
In part, this is what I was alluding to earlier about having a community dialogue. I remember we represented a client, a very affluent client here in Danville. And on the main street that everybody, all 2,000 residents drove by and saw, this house was like kind of junky. And, the board had plenty of reserves to go in, fix the lot and bill the guy back. And they did not want to do it because they were concerned about the precedent of using HOA funds to improve somebody's property. But maybe the members would have been okay with that, assuming the association could go after the guy later. So it's good, as I think, and this is our number 10, as we're advising clients on this new landscape, to identify what the community really wants, right? And then how much pain they're willing to take, how much aggression they want, mediations, arbitrations, even going to court, and that.
Yeah.
Agreed. I've had conversations like with boards and management over the last couple weeks, and there's communities, especially in the Tahoe area, but pretty much all of Northern California that are in extreme fire danger situations. And they don't mess around with barbecues and firework lighting off because they can't. Like, it could be a matter of life and death if a fire gets sparked. And so they have legitimate, well-founded concerns, and they're like, our community wants us to aggressively enforce those kinds of threats, stuff like where you leave your trash cans out and bears come, and you've got those kinds of animal problems in the community. And so, to your point, Steve, I think that it is prompting boards to have these dialogues, and it's going to prompt them. I mean, we're kind of in summer, so some HOAs are like, hey, it's summer, like, that's a fall type of problem. But I do think that they're going to have to make these considerations, especially with I think I would call them like the serious ones where they involve threats to safety and threats to health.
A lot of people are raising the question about leveraging the reimbursement assessment power. So as an example, the board sends a notice out because Sally hasn't brought in her garbage cans. And management sends the letter, management charges an hourly fee that the association is going to pay. And, the night before the hearing, the violation is cured. So is there still a purpose for the hearing? I think the answer is yes, so long as the notice of the hearing included not just the potential fine, but also potentially reimbursement assessments for any manager or legal fees for that matter incurred. So at the hearing, they can't impose $100, but they, I think, correct me guys, you guys are in the trenches, but they could impose a reimbursement assessment for the legal out-of-pocket expenses. Is that right?
Yeah, I think that is right, but it needs to be set forth in the hearing notice. That, even if there's a cure, the board reserves its right to levy a reimbursement assessment for the costs incurred to set the meeting and hold the meeting. You know what I mean? So in other words, they might have avoided the $100, but they're not going to avoid the manager's time and, arranging the meeting and sending the notice and all that.
Well, Paul, the readers of Horse and Hound really appreciate that advice. Exactly right. All right.
But to that point, we know that some CCRs are very anemic. If we draft them, they're pretty robust in terms of reimbursement assessments, defining what it is. Some communities it may be defined under a different kind of name, but there are CCNRs where there's just no mention, right, of the association's ability to recover its costs that it incurs in gaining disciplinary compliance or, for damage to community properties or things like that. And so for those members and those HOAs, they may want to consider an amendment to their CCNRs. I know those are probably also the same HOAs that are like, yeah, but our members don't vote for stuff. And so, this gets to the, point we've been talking about, which is community dialogues to say, hey guys, fines may not really be a, easy thing anymore. It doesn't really get compliance. Reimbursement assessments, we would do them if we could, but our documents don't say. I'm more comfortable when CCNRs have the underlayment for, imposition of assessments. I think, could you do it in a rule? Sure, but goes back to what Paul said at the beginning, then the HOA has this presumption of having to establish that it's reasonable. And so, depending on what your documents say, you may need to check, you may need to look into a amendment or restatement of the CCNR and not just an addition to the rule or the enforcement.
Yeah, that's a good point. That's a good point, Jasmine, because I've seen CCNRs that are very wishy-washy, if at all, about issuing reimbursement assessments. Then I've seen some very good documents that are very specific that costs incurred by the association to gain compliance can be a reimbursement assessment.
Paul, I think the reality is that the original CCNRs, which are written to conform to DRE regs, do not need to go very deeply about reimbursement.
Okay.
Whereas when an association, engages experienced counsel, now we know from questionnaires or meetings or problems they've had, and so we can beef those provisions up quite a lot. I had a client that had a provision that said, if you make an architectural change without permission, the board can fine you $5 a month. So this guy painted his house, and every month the board fined him, and every month he sent him a check for $5.
Yeah. And
to some degree, that $100 issue now, I think, really forces a board and a community again to think about, how aggressive and what the techniques and how quickly they want to use it. We've been talking about sort of conduct and physical violations, but Kimberly asks a really good question. In the case of rental restrictions, if the owner leases their unit, notwithstanding that they aren't within the 25% and they're not on the waiting list, what should the association do? She raises a question about loss of insurance or higher interest on a loan. It could be $100 is minor compared to the issues. My gut reaction is don't waste your time with the fine. Right. Paul, you're in the court on these.
No, I mean, your example it's just the cost of breaking the rule, right? So I think, again, as Steve mentioned, if it's an important community issue, then it's worth the expense of, being ultra aggressive up front. such as, potentially losing your insurance, or maybe even qualifying as a lendable project. I mean, if you exceed some of those rental restrictions, it affects everyone, because people either can't refinance, or they can't get buyers who qualify for loans because of the project is, over the limits of rentals or something like.
You mean because of the Fannie Mae, Freddie Mac regulations?
Exactly. I mean, that is a big issue for an entire community. So in that regard, it's, I think, a very clear issue that the board is well within their authority to use community dollars, because this is a community issue, to go litigate it, to go get an order that says you cannot do this.
Agreed.
Yeah.
Guys, we have 9 more minutes, and I was gonna sort of identify some of our takeaways. Are there any things you would, in your final few moments, have any thoughts you'd like to share before our summary?
I mean, I think that boards should just take a beat. I know there's been a lot of consternation in the industry. Sit down and think through health and safety, whether it's physical stuff or like conduct stuff, and coalesce around what that is. The rest of it's $100, and I think it will prompt review of enforcement policies. And, I think that that's not necessarily a bad thing to go through for communities that have just kind of been on enforcement autopilot for a long time, to sit down and reconsider. We just have our compliance person send out the, trash can violations, and, maybe it might prompt some associations to say, all right, well, one person's going to be the example, so that homeowners understand, this is the set of conduct we agreed to. We need you to all follow it, because otherwise you go to Paul.
Right.
Paul, anything else?
Yeah, I mean, I don't want to sound like I'm, promoting litigation, but it works. And it doesn't, and sometimes it works before you even you file the case, and all of a sudden the violation goes away, and then now your case is moot. The good news is that we have law in California that says, if I filed my case and you complied, I still get my legal fees. I can go to the court and say, hey, look at that, we prevailed in the case and we didn't even get to a trial. And now I can go to the court and ask for the legal fees the association incurred, and having to, go through the ADR process, have it not be successful, file a lawsuit, and then all of a sudden the owner, clicks in and says, wow, this is going to cost me a lot of money. I better just, comply. That doesn't get them out of the potential of the HOA now asking the court for a reimbursement of their attorney's fees.
So I think, one of the most frustrating things about the law is that if an owner cures a violation between the time of the notice and the hearing, boards cannot impose the fine. I mean, we all know that's so counterintuitive, but that's what the law says. Again, if there's an expense incurred, the lawyer wrote a nasty gram, or the manager did, then there is the right under most governing documents to impose a reimbursement assessment. So for me, the takeaways are, number one, we need to take a look at the fine policy schedule, the fine policy and the other rules and the CC&Rs, and decide, whether they need to be amended, including by member vote if necessary, to give the board more tools now that the legislature has really neutered the fining process. And that would include not just procedurally, IDR, ADR, attorney fees, I don't know, maybe mandatory arbitration, I don't know, but also refining things like continuing violation and health and safety affecting common area or personal owner's property. And that would be subject to, again, this community dialogue. Paul mentioned, the tools he needs to succeed in court, letters to the owner dialogues. And I also think showing the judge that there was a community dialogue that supported these aggressive actions, which is now what the board is charged to do. carry out their duties under the governing documents. We didn't say a lot about this, but it does remain true that the board has the right to impose other sorts of discipline. Some communities, for example, can decommission the fobs, requiring an owner to come in as a guest instead of as a resident, which can work depending on a lot of things, including, the configuration of where the guard gate is. Suspending privileges, obviously, Ashley, like you asked, suspending use of the pool by the resident or the tenant. Jasmine has raised a pretty intriguing question, suspending a member's right to make certain architectural changes. I would say that doesn't apply to those predicated on disability needs, but more like aesthetic changes. And there may be other things. I don't know, we kicked around the idea the other day that maybe in a San Francisco condo, the security people don't need to hold on to packages. I don't know, there's a lot to kick around there, but these are the sorts of things that I think we want to encourage our clients to think about as they make changes. Definitely changes are needed, there's no question. And changing the fine policy to reflect the $100 rule does not require the 28-day notice because we're just conforming to the law. But again, everything else is going to require and should be based on community wishes about how enforcement should go. So a lot of questions have been asked. I think we've covered maybe half, but there are plenty more. I am very happy to say that Paul and Jasmine and Jill will be on it. Other than that, Jill, any closing comments you want to say?
I wanted to kind of play devil's advocate for a second, but I was like, play the nasty homeowner. I live in a condo association, and actually I love my condo association, which is crazy, but let's pretend like I wanted to be super abusive and store crap out on my balcony and then get in trouble, but cure it real fast before they have the meeting. Then what happens? Can I just do that over and over again? I know you guys talked about it extensively, but I wanted a fast answer.
Yes.
Like,
Yes,
Yeah.
everyone agree,
You
yes.
can avoid a fine, but if your documents have a very strong reimbursement assessment, the board can reserve the right to assess you for the cost to gather the board together, or have the manager arrange the meeting. You know,
Your
so,
letter,
right. But
All right.
that's, this,
Yeah.
yes, assuming that's assuming that is in the documents.
yeah, we're like the weathermen though. We don't make it rain, we just tell you that it is. Right.
that one was from French.
One of our colleague, Robert DiNicolio, he's a great attorney down in Southern California. And one of his comments about this on social media after was basically, everybody go park your RV in front of Senator Wahhab's house and let us know how she likes it.
One of the first questions, Jasmine, we didn't answer was, who was behind this law?
Senator Wahhab.
And and obviously she had a constituent who got fined by her board, right?
I'm assuming something to that effect, yes.
Yeah.
So again, it's a legislative overreach, but it's what we've got to deal with us. I don't want to encourage boards to just like, oh, well, let's wait. This will get fixed next year. Maybe it gets fixed and made better, but I don't want to, sort of make their enforcement process between now and some future date topsy-turvy. Like, I do think it at least merits boards sitting down and reflecting on what do we want. Obviously enforcement hearings that have already happened, like those remain enforceable. The outcomes and monetary penalties. It's just boards may, need to consider, hey, if you used to do $1,000 fine, and then all of a sudden on July 1st, you're limited to 100, if a homeowner challenges your prior fines, it might have greater scrutiny.
Oh, wait, I'm so glad you mentioned that. What about fines that already exist? Can boards pursue those in small claims court or otherwise?
Sure.
Good, okay. All right, good. We needed to end our program on a positive note.
Okay, guys, My email is in the chat, so if you don't already have it, you can get it there. Feel free to email me after this if you need anything.
Thanks, everybody.
Thank you.
Paul, Jasmine, good seeing you guys.
Thank you.
All right.